This is, can't hear it different. Okay. Well, if you can't hear a difference, that means the microphone's not working either. That's a problem. Because I did not just spend $150 on a microphone for the microphone to not work. All right. Well, let's jump into it anyway. I've delayed you all with my idiocracy.
Wow!
Oh, right, I forgot I can't hear anything. Okay. I'm gonna have to fucking play around with this because I don't understand. All right, so we're at another sidebar. Sorry for the confusion today. Yes, I have sound effects on this thing. So we have little sound effects that we can add. All right. So this is the first day. We went back to day one. So here is another side. Already ready to jump in? We all good? The class is ready? Class is in session. All right, let's get to it. Okay, there's a sidebar conference as follows. The court. I don't know. The court reporter. I'm having trouble. Yes, we know you are having trouble, Madam Court Reporter. You are miserable. Well, this is the first trial, so I don't really remember how the court reporter was handling it in the first trial, but you know, that's neither here nor there. Side effects over here so I can use them when we are at the necessary point. All right. Mr. Lally, with regard to this witness, so they were in the room around the same time, but they did not see each other, the court. Okay, that's what I thought. Yeah, she does. She has that odd thing where she's like talking into it, which is super different than because our court reporters in the courtroom type. They do have the little typer thing, the stenography machine. Okay, so that's so the next witness is conversation between her, meaning Mrs. O'Keefe, Mrs. Erin O'Keefe, and the defendant in regard to what happened. With this witness, it may well be hearsay. The court. Okay, so no instruction, Mr. Lally, unless the court feels it's appropriate for the 2021, which I'm fine with that, if that's what the court can do in the final charge. Just to confirm, if I may address the court, I'm just making sure. There was some indication on a report that Paul O'Keefe had told the police that he did not go over to Karen and John's place because they were fighting or something like that. That's what you're referring to in terms of when you say you're not seeking to elicit that from him, Mr. Lally. Great. Oh, correct. So he gets that information from his wife, not directly from your client. But no, I'm not seeking anything about Mr. Yanity. Yeah, then that's fine. The court. So you don't want me to draw attention to it with the instruction. Lally, correct. Court. Okay, thank you. Whereupon the sidebar conference includes. So now they're back to Mr. O'Keefe. And that's our. It's very interesting. In general, they are approaching these sidebars. Because really, it's basically Lally just being like, I'm a really shitty thing coming up. Like, I'm going to do a really fucked up thing. And I'm just giving the court a heads up of the really fucked up thing I'm about to do. But here's the really fucked up thing I'm gonna do, and Your Honor, I'm gonna do it whether you like it or not. Cool. We're halfway through this day, and we day in the third. These little blocked out names are the children. So they've redacted. At least in this case, I mean, I realize that there's conspiracy theories in a lot of cases, but in this case, there's like less. Now, that's easy. Okay. Lunch. Not too many sidebars on day one. This is interesting right here. It's going to be on the. He states like he says an objection, and because they don't do that stuff. Here he does it. I remember that. Requested by Mr. Lally himself. Lou, what are you doing, Bubs? What are you doing, Pookie? All right. Mr. Lally. So they are not marked as exhibits yet, but what I would like to do is show this witness some video from the ring, whether she's on the ring footage or okay, so I am just the court. Is this going to be agreed upon exhibit? Is this going to be an agreed upon exhibit? Why are you asking the same question twice? Lally, just explain which one it is. Like probably I think there was one when he arrives back at the house from the hospital along with his friends and Miss Roberts, and then there is one when Miss Reed arrives with her father, and then basically just to identify who these people are in the videos. And then there's a couple just in reference to sort of snow removal from the driveway and when that occurred. Like, yeah, the court said that's fine. Let's mark it as an exhibit. Yannetti, that's fine. The court. Again, very interesting. It is you can tell from these sidebars that the defense is really trying to be respectful and is trying to be like agreeable, not to the disadvantage of their client, but to a point where things flow, right? Because in trials you don't want to like be up there every 30 seconds and annoy the jury, because the more sidebars you do, the more annoyed the jury gets, and nobody wants that. So the defense is sort of trying to just be like, no, it's fine, it's okay, we're going to agree to that anyway, it's been authenticated, this, that, and the third. But unfortunately, the prosecution / Commonwealth seems to really freaking doing anything reciprocal for the defense. And that's when you have to start reevaluating as a defense attorney. If they're not going to do it for me, why would I do it? And you'll as like you can see like day one they're being more agreeable, but then as like day two and day three, they're like fuck. Okay. It's not really. Do I have maids of my housework? Are you volunteering for the job? I'd pay. Could you imagine? My house would be clean all the time. I would be so happy. Like, fetch me a seltzer. They'd be like, yes, ma'am. Yes. We'd all talk in British accent. I'd make everybody talk in a British accent. That would be like mandatory. I'd want it was like some British like house. Like very Versailles-esque. Well, that's French. So, but you get what I'm saying, right? You get what I I'm like, I think it should be British, and then I'm like, let's do it like I don't. That's why my house is a mess. But he's going through sidebar things. Hello, Lou. Yes, posh English. Posh. I think I'm the only person in the entire world that can't do like I try, I really do, and there used to be when I was younger. I don't know if you guys remember Miss Cleo. Do you remember Miss Cleo? Myself, really, really. I used to be able to slay a solid. I would I had like commercials memorized when I like repeat them nonstop to my family when I was. I think my mom it like Long Beach Island, and I can do Jennifer in really blonde too, but that's about it. Mm-mm-mm. Mm-mm-mm. Okay, so that's end of day one, which is fine because we did all of day one. All of day two. We got up through, we need to do it a 5-3 now. Let me bring that up. Mm-mm. 5-3. Sidebar. Not scroll through. This came out Friday night. We're Katie McLeod. There looks like there's a voir dire of Katie McLeod there. And then they have the openings from when they go to the scene. 3 the Greg Woodbury, Daniel Whitley, and Jason. Now it's funny because it's not funny, like funny, haha, but like interesting because a lot of these people we didn't hear from in trial number 2. So that's always going to be interesting to me, is that we didn't really get to hear from some of these people in the second trial. Okay. Yes, I did see some of the interview with Carrie Roberts. She annoys me, and my personal favorite, obviously, was the part where she said, "I know one day I'll see John again, and I know that Karen won't, and that's how I sleep at night." So, Miss Carrie Roberts, to be completely honest with you, needs to take several seats. I feel like she's like asking to be sued. And like I feel like almost in a way she feels like she's um like left out because she's not in the lawsuit. So she's trying to stay relevant, which is absolutely insane. I, I'm just I don't know. I don't like it. I don't like it at all. Oh, this is funny. This is really interesting. An open. They're doing trial. She loves to fucking slam Alan Jackson. So we're talking like right here at the top, bottom of the page in the top. The second thing is, yesterday, Mr. Jackson, you referred to the court reporter as Nancy. We are much more formal than that here generally, but my big concern is that I've known Madam Court Reporter for 35 years. I've never called her by her name, particularly in a case where people's personal information has been put about on the internet. I cannot allow that, all right? I don't think you meant anything by it. Mr. Jackson, I certainly didn't. We have to be extra careful. In 35 years, she's never called her Nancy before? So when she sees her out in the town, she's like, oh, hello, Madam Court Reporter. Oh, hello, Madam Court Reporter. Can you please send Madam Court Reporter a drink on me? Well, the bartender, who the fuck is Madam Court Reporter? Oh, the lady down over at the end. Can you be more specific? I only know people by names. Oh, you know, Madam Court Reporter. Who the fuck's Madam Court Reporter? Oh, you mean Nancy? You mean Nancy? Oh no, I don't know her real name. I've only called her Madam Court Reporter for 35 years. Why would I bother to get to know the name of somebody who's worked in my courtroom for 35 fucking years? God forbid. In the 35 I've known her for 35 years. I've never called her by her name. That's not at a sidebar either, by the way. This is an open court. This is outside the presence of the jury, but there are people in the courtroom listening to this. Okay? And I will tell you that being lambasted by a judge in open court, okay, is one of and Alan Jackson's a pro. So this is not the first time a judge has tried to put him in his place. She does Karen doesn't Bev does not do it well. And this isn't gonna okay. This isn't gonna face him or do anything to him except grate his nerves. Okay? Because if this happened to me, okay, and again, Alan Jackson has been doing this for significantly longer than I have. What this would do before the trial started is get under my skin a little bit. Not a lot, but it would get there just a tad. Just a tad. Like it would throw me off just for a millisecond. And I'd be like, and then when I went down to lunch to talk with my colleagues, I would literally be like, did you hear that bitch? Did you hear that bitch? Did you hear what she said to me? I called that woman by her name. And she was like, don't do that. You call her Madam Court Reporter. And it would bother me. Just a little bit. Enough to get under my skin, just a little bit. Bev knows what she's doing. She plays like this dumb little, I go to the Cape and I get drunk. But she knows how to play it, which is very evident here. And I don't know if anybody would analyze it that way other than me. But that is what she's doing. Thank you for the follow. We have gotten 2 new followers so far this live. So thank you for joining. I appreciate you being here. Pissed me off. She didn't even let him finish his sentence. She said, he's like, I certainly didn't. And then she's like, I'm not saying you did. We just have to be extra careful. Fuck this bitch. Wants them to approach before she wants to sidebar before any video is shown. Leave it to Bev. Leave it. All right. Test. Here, right down here. I don't know if you can see this. I don't need 100 pictures of snow. I'm just saying, all right? The jurors aren't going to look at 600 exhibits. I can't imagine that they won't. And then Alan Jackson finally down here. Yes, I'm very aware of the case. Court and I are very invested in that one, and we will be covering that one in great detail. Please apologize to Madam Court Reporter. I certainly did not mean to offend the court. Nobody thinks you meant it, and I think it just underscores the point that the less unnecessary chatter, even during questions, the better. So, like, right now, we know that where Alan Jackson comes from, right? He's a California lawyer, all right? And every jurisdiction does things differently. We know this. We know that every jurisdiction does things differently. We know that at the end of the day, the way I introduce something into evidence in my courtrooms is going to be different than how someone in California introduces something in their courtrooms, because stylistically, judges like things done differently. I can be in front of one judge, and that judge likes something different than the judge sitting in the room next to him. Okay, and you have to know those things. They're nuanced, right? And if you're not from there, you're not going to know those things. Yeah, AJ's right is definitely a see you next Tuesday. But down here, she's like, we are not used to that here. AJ's doing the things the proper way. Like, you're not being certified except as, right? Like, what she's talking about is qualification of expert witnesses, right? And when you are certified as an expert witness, you're certified as an expert witness as one thing. So when he's asking, you're not being certified except as a forensic technician, or except as a forensic scientist, or except as a snowblower expert, right? That clarifies for the record what this individual is specifically allowed to give their opinion on. According to Bev, they don't do that in Massachusetts, which is wild, because I doubt that, number one. And number two, for a record, what the individual is qualified to give their expert opinion in, right? Because if they just start throwing their opinion around, like, let's say you're certified as a snowblower expert, and you start giving your expert opinion on the history and culture of the New York Yankees from 1901 to today. How are you supposed to appeal that if you were never clear about what their certification was? So you object, well, they're not certified to give their opinion on the 1927 Yankees. They can't say, in my expert opinion, the 1927 Yankees were the best team ever. I don't know if they were good that year or not. I have no fucking idea. But you can't appeal that later on down the line for inappropriate expert opinion testimony if you're not clarifying for the record what they're an expert in. Does that make sense? MJ's like not feeling well, so he's not running anywhere. But ladies, men, they have a slight tickle in their throat and they're dying. So I will let you know he's on his deathbed now from a tickle in his throat. The death. All right. We are on to cross-examination of Katie McLaughlin. And this is being done by Nancy, Miss Madam Court Reporter, is all up in the record. Oh, I can't wait. Get through the interesting. I mean, I can skip ahead if you want me to. It's up to you. I scrolled. Oh, I did. You're right. Good job. Good catch, Britt. How long is the statement? Does she need it in front of her? Alan Jackson, no, it's one sentence, Your Honor. Okay, go ahead. So this is during a refresher recollection sort of situation. Just one. I don't think they needed a sidebar for this. Oh yeah, I need a wow for Britt. Where's wow? This is for you, Britt.
Wow!
Followed by this. Make sure you're tapping that screen, guys. Listen, I just discovered that TikTok Studio has sound effects. So be ready. Be ready. Okay, there's like, I could like add my own sound effects too, which I'm gonna have to find and download. So here is, I'm just gonna make sure that you guys can see this. I want to point out something else that Bev did that is not appropriate, in my opinion. Okay, and this is really judge by judge specific. So if you're looking and you can see lines, let me see, I have to like move myself for this one, because I'm going to be talking about lines. Okay, we're going to go back up here. Okay, so look at lines 16 through 20. Okay, it says, did you write that in any report? And what Katie says, I don't write a report in this scenario, my job. And then Jackson says, so the answer is no. And Bev says, let her answer the question, please. Okay, so this is something that you guys saw routinely through this trial, is that Alan Jackson would ask a correctly formulated question on cross-examination that required just a yes or no answer. And the witness, as they're told to do on cross-examination, do anything but give a yes or no answer, right? And you're really allowed to stop them if they do that. You really can be like, you could be like, so the answer is no, right? Because you don't want witnesses on cross-examination to elaborate. You want a yes or no answer, you want to move on. And this happens a lot with cross-examination in her courtroom. She'll say, she'll let them elaborate for like as long as they want to, instead of just simply answering the question. The question didn't warrant a narrative. The question warranted a yes or no answer. And Katie here is like, I'm going to tell you everything. You know, a statement that's 1, 2, 3, 4, 5, 6, 7. And then Alan has to re-ask the question just for clarity. So you didn't write it in any report. No. Sort of hammer the question home for the jury. Like if you ever, oh, thank you, Lori. If you ever sit down ever and read these like just straight through instead of just looking for sidebars, you're going to And this is when they're asking Keenan McLaughlin about her relationship to Caitlin Albert. All right. So there's a sidebar conference. What is the objection? Relevance. How do you respond to this? This witness has a deep friendship with Caitlin Albert. She knows the Albert family. We have photographs of her traveling with Caitlin Albert, going to the beach with Caitlin Albert, going. The court, how old are those photos? I'd say probably they are mid-20s or so. Her age can't be more than a year old, 2 or 3 years old. They have accounts with their friends together. They vacation together. They drink together. They socialize together. She is relationship between Caitlin Albert and her knowledge of the Albert family. I know she knows the Albert family and she knows where, the import of 34 Fairview. I don't believe it's a 30 Fairview. So you can focus on that. The other is too extreme. It's not relevant, and it's certainly not that she knows the family or the court. You say it's relevant to the house, her being at the house, the family, and the house. You can do that. Social media, traveling together is by yes. She was just one of the people at the house that night. Yeah, it's not probative. If any relevance, there's a little bit of, but I'll let you get into that. She knows her and she's been to that house before. Just so we don't have to approach Sidebar again, I've got photographs of them together. You can and show them to Your Honor. For the record, I have never seen any of this. I don't know what counsel is talking about as far as photographs and social media. Mr. Jackson, because it's impeachment, the court. But if you knew you were going to see it, use it. You have an obligation. Mr. Jackson, I didn't. And then she sends on a 10-minute break. So now there's a voir dire. There's going to be a voir dire. Show the facts and we'll have a short voir dire. We'll come back out. Whereupon the sidebar conference concluded. Now, do you guys remember if this was done in front of the jury or this was done on television? Do you want me to read through the voir dire? It's up to you guys. It's up to you. I'll do it if you want me to, but if it was done on television, you could just watch it happen in real life. If you want me to read through it, I will. If not, we'll skip over the voir dire. It's interesting what Bev finds and what Bev finds to not be relevant, in my opinion. Like, how is her relationship with Caitlin Albert not relevant? This. Lally Cross also gets a chance. Okay, so now we're going to get back to, so Lally is objecting to Rule 14, right? The court says, I agree these exhibits don't come in, but based on the voir dire and the answers and exactly what the relationship, the social extent of it, friends on social media, those areas, you didn't quite get coming in. Aside is Bev saying, you had said they'd been out drinking together and all of that. One person was holding a beer at a beach and a crop. So that's not a bar room or anything. Jackson, no, I didn't suggest they were in a bar room. That's what I was referring to. That they, I'm assuming that if Caitlin was drinking, she was drinking too. The court. You didn't get it from them, so you can't do that. Ms. Jackson, I'd forgotten to, and I should do it here at Sidebar. I had forgotten to actually refer to the third photograph. Is it J or K? May I have those? I think I forgot to mention that this was K. That's how it's been marked. The court. Okay. They look like young girls in bathing suits. Thanks, Cass. I'll remember to wait to talk until I'm done scrolling. They look like young girls in bathing suits. Not the court sexualizing Caitlin Albert. Way to go. Let me get down to 22. Okay. Mr. Jackson, I do want to make a record that I disagree with the Commonwealth in terms of the Rule 14 objection. The reason that we disagree is that this is pure impeachment, as the court well knows. This is not something that we were going in the case in chief. Indeed, I was never, and I can show the Commonwealth and I can show the court, my order of proof in terms of my outline. I literally do not bring photos unless ... She denied the I don't know why it says unless ... Like, I guess the stenographer, like, wanted to add a ... but, like, said ... Denied the relationship or was trying to distance herself from the relationship. I think that's obviously some level of deceit on her part. She knew that there was a relationship. I can prove there was a relationship with these photos. The level of the relationship is up for the jurors to decide. But she said, her first answer, Your Honor, was I said, who is Caitlin Albert? And I just left it open for her to say, she's a friend of mine. We went to high school together and I've known her for 10 years. And she said, none of that. What she said is, there was a girl in high school with that name. And that's a lie. And that is why we are. And now she's changing her story. Because I'm about to impeach her with these photographs. I don't think that's a violation of Rule 14. This is pure impeachment. Mr. Lally. What I'd say is I don't think that that is a lie. I think that's exactly what was born of her testimony in voir dire. The last thing I would just to flag for the court is this is a witness who was Mr. Kearney. She's talking about Turtle Boy on this specific, the court, Mr. Who? Mr. Kearney on this specific issue. So if we're going down this road as far as impeachment, I intend to get into that. The court. Come to Sidebar before you do. So I find that it is a violation of Rule 14. So these photographs won't come in. We will keep them handy in case you need to refresh your recollection. They are not to be shown on the screen. Mr. Jackson, understood. I expect that the press will not see these photographs. Jackson, no, of course. The court, of course not. They've seen all sorts of things. I was told this morning that one of these photographs has already been circulating today. Jackson, not from us. I'm just saying, but of course, to be concerned with things. What day is this? 5/3? This is really good, guys, and we have a lot to talk about on this one. I understand. Not from us. I'm just saying, but when you said, of course not, I have to be concerned about these things. So she's essentially, let me just get through this and then we'll talk about it. Not saying that. Yes, you are. Yes, you are. You were literally saying that they're leaking out. Mr. Jackson, we don't play those games. Am I allowed to refer to the photo, just not show them? In other words, what is this a photo of? Does it appear to you to be a photo taken with Caitlin? The court. No, you can talk. I think she will tell you she was at a Jackson. Okay. The court. You can talk, and if she doesn't, Mr. Jackson. Okay, I just want to make sure I'm clear. I do not want to overstep. Can I ask, have you ever been photographed socializing with anyone? Sure. Okay, I think I'll get the answer and then I won't have to show it. Okay, all right. All right. This is hectic. This is hectic. And I can see why they don't want these out. I can see why they don't want the sidebars out. Because anyone that has any sort of legal background is going to look at these and they're going to say, holy fucking shit. Does everybody understand the Rule 14 violation and why Alan Jackson is saying it's not a Rule 14? Rule 14. Does everybody understand that distinction? And why Bev is wrong? Okay. All right. So Rule 14 is discovery in Massachusetts, right? So under discovery, there's reciprocal discovery, which means that the defense, if they plan on using something, they have to give it over to the prosecution. Okay? There's a caveat. There's a caveat to that. The caveat is if you're going to use something in impeachment, meaning you don't intend to use it in your case in chief, right? You don't intend at all unless someone lies. You don't really have to turn it over because you don't plan on questioning it, right? It's technically not discovery because everyone's supposed to tell the truth when they're testifying, right? You swear to tell the truth, the whole truth, and think what the truth will help your God. So you only have it in your back pocket in case someone decides to lie. You don't actually plan on using it because everybody's supposed to be telling the truth. So in this case, they didn't give the photos over of Caitlin Albert and whoever the fuck she's supposed to be kicking of Caitlin Albert and Katie McLaughlin, because why would Katie lie about being friends with Caitlin? She has no reason to lie. There is no absolutely reason to lie. Why would she get up there and be like, no, she's just some girl in high school, when in reality they're friends, right? So if she gets up there and she minimizes it and is like, no, fuck this bitch, I don't know her, we went to high school together, I've never seen her before in my life, then that's when Alan Jackson can grab the photos and say, oh, that's really funny because I have this photo here that shows you guys drinking a bunch of beer on the beach. So you did know her. That's impeachment. Not something he would normally use. No reason to normally use that because why would somebody lie about that? They're saying it's because it should have been turned over, but it would have never needed to be used if she told the truth, which makes it impeachment, which makes it not a Rule 14 violation. Does that make sense? Does everybody understand that? It's a little bit complicated and it's a little bit of like a weird, nuanced discovery legal principle. But that's what they're arguing about in this sidebar. And to be quite frank, Bev is 100% wrong on this. She's 100% wrong on this. There is nothing here that demonstrates to me that this is actual discovery that should have been turned over prior to the trial beginning or prior to even this witness testifying, right? Because why would you need it? Why would you need it? You wouldn't. You absolutely wouldn't. So I'm confused. You're confused. We're all confused. But here we go. Here we go. So that's that. Okay, hold on one second. And check my text messages real quick. Oh, you know what I can do? Okay, well, I'm going to because Courtney and I are going to try and figure out how we can make this work later, but Well, yeah, I agree with you. I think that the issue here is that Bev made a significant amount I wouldn't say inappropriate, um, incorrect rulings. This is an incorrect ruling. This is 100% an incorrect ruling. And I'm not just saying this because I don't like Bev. Legally, this is not a sound ruling. I mean, I'm trying to like inappropriate is probably a correct word also, but this is in no way, shape, or form. This is not legally sound. There's no legal principle or legal basis that she's basing this on that makes any sort of sense whatsoever. And I don't practice Massachusetts, but I am very familiar with Discovery, and I mean, like I get Discovery every day, right? I have to turn over Discovery every day when I'm on trial. So I fucked this one up. This is the wrong ruling. This one's very interesting to me. Good afternoon, Sharon. Okay. Let's find another one so I can be as upset and equally as mad that Bev does not know the law at all. You know, you go through life and you think that judges like are supposed to know the law, right? Like, you know, you're like, you see a bunch of people like, oh, judges are the best, they know the law. And I mean, like, they're supposed to. And then you realize that they don't. Oh, hello, Steve. And new followers so far this live. So welcome to our new followers. We do this pretty much every night, go over cases and stuff. So if you want to learn from a real criminal defense attorney who knows what's going on in courts, that I am your girl. And I will teach you what you need to know to understand all of these crazy cases. So if you want to follow, please do. And I put my YouTube and my Instagram up there as well. We don't live stream in New York. Okay, this is a question about Proctor, it looks like. So there's a judicial review board, but so judges are allowed to make shitty decisions, essentially, and that's what appeals are for. That is what appeals are for. I said that weird. Okay. All right. The court. So are you objecting to the argumentative nature that the question began with? Okay, Bev, just hand feed him. Just hand feed him the fucking objection. Just hand feed it to him. Hand feed him. Like, just in case you didn't know what objection to make, I'm going to tell you it's argumentative. Okay, you can't do that. The Commonwealth didn't now. But now that they have objected to some of these questions, the objection is sustained. Into impeaching her with correct? So if there's a continued objections about the argumentative nature, it will be sustained. If it's strict impeachment, ask the question again. Mr. Jackson, I'll rephrase that. It's funny how she never, I'm trying to remember to not talk while I'm scrolling. Okay. Okay. Their sidebar. Here we go. at the request of Mr. Lally. Lally, it looks like, starts to have the sidebar without the entire defense team being present. So Bev is like, wait until everybody's here. And this is about Turtle Boy in this one. So that's interesting. So Lally says, so my next question is how she knows. And then this sort of gets into the area of not only Mr. Kearney, who's Turtle Boy, but this witness also had a visit from a defense investigator in which the defendant was in a car parked outside of her house. That defense investigator sort of pushed his way into the home with her parents to try and speak to her at one point during the pendency of the case. Mr. Jackson, Your Honor, that is true. First of all, I think it's supposed to say that is not true. Yeah, that's supposed to say that is not true. It's funny how the mistakes in the language are only on the defense side. That's interesting to me. So that's supposed to say that is not true. First of all, there is no male defense investigator who has ever approached her. We did actually have a very polite, have an investigator, a female, knock on the door, have a very polite conversation with the McLaughlin parents, who said she would rather not speak with us, and then we left, which is and well within, actually, it would be the court. I understand. Mr. Jackson. So nobody tried, this is the Katie McLaughlin testimony. So this is going to be day May 3rd. Mr. Jackson. So nobody tried to push their way in. I don't know where Mr. Lally is getting this other than the witness, and she wasn't even there. We never made contact. Is it something I need to look at right now? Because I will. Okay. Thanks, Susie. Okay. I appreciate that. Okay. Thank you. All right. So no blah blah blah, the court. So I guess I'm a little confused as to, you said your next question is going Lally. How she became aware of those names after the fact. The court. I thought she testified she saw it on the news. Jackson. That's what she did say. Lally. Again, I don't know that the news is necessarily Channel 5, Channel 4, or things of that nature. The court. You brought it up. I'm going to let you lead through what do you suggest, Mr. Jackson? Mr. Jackson, I don't think this has any, if this is the Commonwealth's way of trying to sully the defendant, the court. No, I'm asking questions on how you brought it up about how she learned these names, knows these names. Jackson, she's testified to it and the fact that she watched the news. The court. That was on voir dire. That was on voir dire. Thank you, Bev, for repeating yourself 72 fucking times. Jackson. And I think he should be able to lead her and say, court, well, that's why I asked for suggestions. Why is she so sassy? Jackson, is it true that you learned this on the news? That was your testimony, and leave it at that. The court. I'm not going to let you get into the Kearney stuff through this witness. There may be other witnesses, but not this witness. You can lead her what she learned by the news broadcast. If it was social media news, that's fine. Lally understood. By the way, guys, I'm reading this for the first time with you. So my reactions are, oh, I know that's why she's sassy. It just never surprises me how sassy she is. So my reactions are real on what I'm seeing and hearing for the first time. So this is me reacting in real time. Sidebar. This is just Jackson. Thank you for the follow, Ollie's mom. We have a very fun time here. We have a good time. So if you want to learn this stuff from a criminal defense attorney, which is me, follow, enjoy. We have a good time. We do this stuff every night. We go over all the cases, all the fun cases. And I try to break it down for you guys as easy as I possibly can. Thank you for the follow. Without any bullshit or conspiracy theories. Thank you, Cassidy. So this is the Kushiji. This is just, oh, thank you, peanut butter. This is just what he's, so. Oh, thank you for the heart hands. Just Bev being a dick. Thank you, Kels, for the follow. We're up to 8 new followers. Thank you, guys. So here, this happened, thank you, Peach, during like real life, like we saw this. Thank you for the follow. He's just clarifying their position on the Rule 14 violation. Right down here, he says, which is a bastardization of the truth. He has such a great way with words. I love it. Yeah, Carrie gave that. Oh, and he cites cases. But we're gonna. This is all when they were at. They really, so it's just really interesting because they removed so many witnesses for the second trial that I forgot that half of these people existed. I literally forgot that half of these people existed. I can't wait for trial 2 with all of the objections and all the sidebars for like the expert. Sidebar. All right. All right, here we go. Lally again with the maybe approach. No, dickhead, you can't. Because I said so. Unsung hero. Unsung hero. All right. Oh, it's always a good when they start with, well, it's hearsay, but it's not for the truth of the matter asserted, Your Honor. But the state of mind of this witness, as far as his treatment and diagnosis, as far as receiving the information, not in conformity with what he's observing on the patient, and then seeking more information. Wait. Those are words. They're certainly words. Those are words. The court. So you have to lay a foundation for that. Lally, I think I did as far as what his observations were. The court says not sufficient. Ooh, she said it wasn't enough. Bev actually said something wasn't enough to Adam Lally. Mr. Lally, I think I did as far as what his observations were. Not sufficient. Lally, if I don't have the statement, I can't ask him if it was what he observed. The court, what do you say, Mr. Yannetti? Yannetti, well, first of all, I have a question on the relevance of his state of mind as it pertains to the issues in the trial. And I think it's just a backdoor way to get in some sort of hearsay corroboration of Miss McLaughlin's testimony. Oh yeah, we need a wow.
Wow!
And now Lally's offended. Lally's offended. Corroboration? The jury's already heard from Miss McLaughlin as to what the statements were. We've also already heard those statements as related by two other witnesses separately. The court, so what is it exactly? It's a good time for our lunch break. What is it exactly that you want to ask him? I want to ask him what he was told as far as what firefighter McLaughlin learned from that person. And why do you say that's not hearsay? Again, the follow-up question that I'd like to ask about is whether or not that explained to him what the injuries were that he observed, or that he, for what purpose. Again, I think it goes to his treatment in relation to Mr. O'Keefe and how that was handled. Well, what do you say, Mr. Yannetti? Yannetti. Well, I say that, we haven't received any notice that this witness would be offered as an expert witness. I think there has been a lack of foundation in terms of his qualifications to give an opinion of the status of the injuries and whether they comport with what he's viewing. He's not an expert pathologist, or he hasn't been qualified. So I would object on that basis as well. The court, isn't this what you all put in through another paramedic, that I did tell Mr. Jackson he needed to lay a different foundation? All right, we'll take a different lunch recess. When we come back, you can argue it to me. Thanks, Denise. Those were a lot of words. Those were a lot of words, and if you are confused by those words, you're not alone, because even though I'm an attorney, and I'm very familiar with hearsay, am confused by the words that were said by Adam Lally, because they don't make much sense in terms of trying to get this information into thank you for the follow, Nikki, into the trial. Another objection here would be bolstering. I think that would have been a valid objection here as well, since we've already heard We already heard the same thing from 3 other witnesses, so I think bolstering would have been a good objection as well. But it's not, my opinion. On the little, so doing this on TikTok Studio, it shows you like analytics of your live, and it gives me like a leaderboard on like who like sent the most like taps. I'd like to say that Denise is number 1, in case you're wondering. So thank you, Denise. All right. I think that's what it means, because it says your name and then it has like a coin and then it's, and I think the taps transition to coins. So I think that that's what that means. Yay! Confetti! Confetti! Thank you. Sharon, you're in spot number 2, just so you know. Thank you, thank you, thank you for the confetti. No, Sharon took the lead. All right. Sidebar conference again. Mr. Yannetti. He does, oh, a little cake. Thank you for the level up. You leveled up. Yeah, girl. All right. Mr. Yannetti. My next and final line of cross-exam will be with regard to the injuries to his arm that this witness testified about. And the reason I'm approaching Sidebar is I would like to show him the autopsy photo that the court has previously seen, which depicts the injuries he's described. Given the sensitive nature of it, I didn't want to display that in open court without getting the court's permission. The court. What does the Commonwealth say? Mr. Lally. As far as the photograph, I would anticipate something along the court. Speak up. Mr. Lally. I'm sorry. I would anticipate something along the same lines that I would be seeking to introduce at a later time. The court. Is this what he saw, though, in that short time in the ambulance? Lally. That I don't know. Yannetti. Well, he saw those injuries, whether they had more blood on them or not. The court. These are obviously going to come into evidence. Yannetti. They are. The court. I'm just not sure this is the right witness. Yannetti. Well, I want to explore that, Judge, and if I fail to lay a foundation, I will mark them for ID. But I want to show it to him to see if he will identify it. The court. Why do you need 3? Yannetti. I don't. The court. Okay, I'm going to mark 1 for ID now. If he adopts it, you can put it in through him. Yannetti. Great. If he doesn't adopt it, you can't. Yannetti. I understand. Mr. Jackson, please come back. Jackson. Axon Jackson is like, I'm done. I don't need to hear anymore. I'm going to go sit down now. Thank you. Yannetti. What is the letter for ID? Madam Court Reporter, aka not Nancy. That will be N for ID. N for ID, but not N for Nancy. The court. Thank you. Do you intend to put it up on the screen afterwards? Yannetti. I would. The court. All right, so get him to adopt it. Yannetti. Yes. I can't with these. These are comical. Meanwhile, Jim is Jim, right? Exactly. Meanwhile, she's like, Jim, everybody say hi to Jim. But Madam Court Reporter is Madam Court Reporter, working in her courtroom for 35 years and has never called her anything but other than Madam Court Reporter, which is wild. Absolutely wild. I cannot. Whew. Sorry for the yawning. I am always very tired and I have to go tomorrow to get headphones. So now, oh, that thing went off. Okay, that's fine. It's giving me a headache anyway. We have another large size. Okay. The court. I really do enjoy dramatically narrating these for you. I realize I'm only one person, so it's not as fun if there's multiple people reading these. But I do very much enjoy trying to like dramatically narrate them in a little bit different for each person. So, if I am doing well, make sure you tap the screen because I enjoy doing it this way. But if you don't enjoy it, let me know if you want me to do it a different way. The court. So when you get cropped, if we could also print a copy of that and exchange it for Yannetti. Definitely, yeah, the court. What's been produced? Mr. Yannetti, we wanted to print it. The court, okay. Yannetti, we wanted to print it so that you could see it before we put it up there. The court, that's great. And then we will swap the exhibits. The court, yes, that makes sense. Yes. Lally coming in with something random. Your Honor, while we are here, I'm sorry, just with reference to what the court had said before as far as Exhibit 160, so Miss Gilman was able to print out a redacted copy. The court, okay, of both run reports for Mr. O'Keefe and Miss Reed. Oh, is Miss Reed going into evidence now? Mr. Lally, with the next witness, probably. The court, okay, so I just wanted to give counsel an opportunity to look at them, and the court, obviously, before I did that. Bev. Okay, that's great. So we'll swap another exhibit later. We are going to need some time today. I need you to let us know what exhibits you have referred to by number during the course of your questioning because it really does not make sense to have 308, 309 when they should be 18, 19, and 20. So I will allow counsel in further questioning to say what was previously marked Exhibit 308 and is now Exhibit 17 to do it that way. Mr. Lally. Okay, the court. But if you've already, we will wait until the end of today. So if you already intend to refer to the prior exhibits by their numbers, we will do that for today. Lally, okay. The court, okay. All right. So why don't we, is he ready? Okay, why don't you go over there? All right, so we're going to replace. Okay, this I'm not going to read because they're just talking about replacements. Except this is funny. Yannetti, yes. It's 382. Lally, it's 382. Bev, that's what I said, didn't I? And again, he goes, no, you said 362. And Bev's like, oh, I'm sorry, 382. All right. Did we disrupt that trial for this? The court officer, no. All right, so why don't we bring them right back? All right, so everyone is in agreement with that? Lally, yes. Yannetti, yes. Why don't we deal with Mr. Lally's? We'll replace the John O'Keefe's report. I don't remember the number later today, but for now, this Miss Reed report, by agreement, will go into evidence as is. Jackson, correct. The court, okay, so we replace this later. So we're going to have to spend a few minutes doing that. Jackson, okay. The clerk, and for the record, Your Honor, It was Exhibit 160, the O'Keefe report, Jim. This is... We can't call her Nancy, but Jim is Jim. Jim is Jim. Gotta love it. Oh, God. The hypocrisy. And to be honest with you, like, clerks are, like, given more, like, respect than the court reporters in the courtroom, right? Because they're the fucking clerk. So, like, in the courtroom, it's usually Mr. Clerk or Madam Clerk, right? That is normal. Like, when I have to refer to the clerk, I say Madam Clerk in the courtroom. I don't call them by their names in the courtroom, right? But like for the court reporter, I'll be like, "Oh, Dorothy, can you read me that back?" Like, they're just talking about they're putting out exhibits. The court reporter. That would be N for identification. Okay, N as in Nancy. Deceased. Deceased. I thought Nancy in the courtroom, Judge. I can't. I can't. This is so fun. Is there a laughing emoji? Oh, here we go. The 35 years broke just then. The 35 years broke just then. Mm-hmm. Mm-mm-mm. Promoted. This is so fun. Like, this is comedy. Like, if this was, it's only comedy gold because she was found not guilty. I want to make that very clear. If she was found guilty, this would not be as funny as it. Like, do not get me wrong at all. This is only humorous because she was found not guilty. This type of behavior is inappropriate by any judge. So I'm just clarifying. The only reason I'm finding this funny and laughing is because she got lucky and got found not guilty. Think about all the criminal defendants. Well, here's the thing. I have had people who have appeared in front of Judge Bev before as defense attorneys say that she's a great judge. All I'm going off of is what I've seen in the Karen Reed trial. I can't say she's a great judge because this is all I've seen. But like other people have said that she is very fair in her rulings. I haven't seen that, so I can't say that. But to me, this is really shoddy judicial work. I don't know how you guys feel about it, but to me, I think that this is comical. We're talking like Saturday Night Live comical. Right. If you're not Karen Reed, she might be a great judge. But to me, this is a travesty on the judicial system. I think you're 100% right. I think, thank you for the follow, Jen. I think Trial 2 is going to be a nightmare compared to this. I think Trial 2 is going to be an absolute clusterfuck. And it's going to be really funny for me because I still have my notes from Trial 2 to go back because I was writing down when they would side what I thought the sidebars were about. I had to find my notes. I don't know where I put them. So if I still have them, I'm very curious to see if I was right about what the sidebars were. There absolutely is a reason they didn't want the sidebars out and why they kept them. Now, to be fair, during the reason why between the first and the second trial they weren't allowed out makes sense, right? Because there was still a second trial to happen. That makes sense. Why the Commonwealth fought so hard afterwards and opposed the release of them is always going to confuse me. Because when Bev issued her order, she was like, no, release them. I don't give a fuck. So my question has always been is if Bev didn't care about them coming out, why does the Commonwealth? Because these truly, they make both look bad, right? But in my opinion, it makes Bev look inept. But the Commonwealth's doing their job, right? I mean, like, but Bev is making bad decisions. So I'm not sure why she was like, no, it's totally fine, release them, release the hounds. And then the Commonwealth's like, no, we don't want anyone to see these. So was the Commonwealth trying to protect Bev, and then Bev's like, no, I don't care, I don't need it. I'm doing civil court now. Like, I don't give a fuck. Or is there something in here that is so damaging to the Commonwealth? And if so, what is that? That's my question. She's pretty protected, yeah. But not completely. You don't have complete judicial immunity, right? If you do bad things as a judge, you are going to get removed as a judge. We've had like multiple judges in my county removed. It's just very interesting to me, that juxtaposition. Okay, this is a sidebar just about schedule. Okay, and that's the end of day 5-3. I'm gonna be finishing up soon in a second, Cass, anyway. So, does anybody have any questions thus far about anything that we've read, anything that we've seen, um, anything that we've gone over so far? I want to give everybody a chance to like ask whatever questions they want. It could be far. It very well could be. I want to remind everybody to follow my YouTube and my IG. I'm going to be posting some highlights from tonight's live on there, so you can catch up, or if you missed any parts of it, I'll definitely make sure you check that out. If you came in late, I think I'm going to start posting the lives on the YouTube, so that way you guys, if you missed it, you can watch those. If you guys want me to do that, I'll do that. But make sure that you go and follow it. I know the whole first half hour is going to be me and Courtney struggling to figure out how the mic works, but it's fine. Good night, Tegan. I love that name, by the way. But yeah, I could start doing that. My goal is like my YouTube is very small right now. I'm trying to build that up. That's like one of my goals for the new year. So I was trying to hit 500 subscribers before January 1st. I'm going to. I'm going to start. I'm actually going to do that tonight. I'm going to upload this one tonight. Thank you, Tegan. So what I'm going to start doing is after every night's live, I'm going to download them and I'm going to upload them to YouTube. You're very welcome. I hope everyone had fun tonight. It's great seeing everybody as usual. I am going to try and figure out some of the technical stuff. It's right here in the middle. It's GIANCRSTESQ. That is, I have a theme song for YouTube. I'm going to have to upload it. That is my YouTube. So definitely check that out. Thanks, Tegan. And I will be going over, I'll probably have a longer live tomorrow night because it's coming close to Christmassy time and I will not be able to do one on Christmas Eve or Christmas Day. So, oh, thank you for the you're amazing. I love that. So we'll do one tomorrow and Tuesday, and then not on Christmas Eve or Christmas Day. And then we'll get right back to it after that. Does that sound good for everybody? Is that work for the collective? I think that should work. All right. All right, cool. So then I will see you guys tomorrow night. Probably 6 o'clock Eastern Standard Time. and we'll go through some more of the sidebars. All right. Good night, everyone. I love you all. Have a great night.